Do you think that just because a jury gives you a few $1 million in a verdict, the doctor's automatically going to write you out a check right then and there? You want to know what this is about? Come join me for a moment as I share with you exactly what I'm talking about, and I try on my tuxedo shirt in preparation for my daughter's wedding. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now I'm in the process of trying on my tuxedo shirt for my daughter's wedding. I want to make sure everything fits. So you're going to see me getting dressed. You see I've got my suspenders on, I've got my cufflinks out, and I've got to start putting them in. I want to make sure everything looks great. And now at the same time, I want to share with you some great information about what happens if you bring a lawsuit against your doctor. And now 2 or 3 years later, when your case comes up for trial, now a jury gives you a verdict in your favor and you are thrilled. You are so ecstatic. Why? Because the jury has now vindicated your claim. Now they turn around and say, hey, you know what? You deserve to receive X millions of dollars for all of the pain, the suffering, and damages you incurred because of your doctor's carelessness. Do you think the doctor's going to take out his checkbook right then and there and start writing a check paid to the order of $5 million? The answer is no, he's not. So while I'm sharing that information with you, let me start putting together my cufflinks, because you know how tedious this can be, as I go ahead and explain what this is about. So here's the scenario. Let's say you were being treated by a doctor and the doctor was careless, and his carelessness was a cause of your injury. And now you believe that your injuries are significant or permanent. And guess what? Now you're unable to go to work. Now you're unable to do your daily activities. And now you're unable to do so many things that you couldn't do before you underwent this doctor's care and treatment. And guess what? You go ahead and decide, you know what? I have to bring a lawsuit because the doctor's not going to write out a check in order to go ahead and pay for my kid's education. He's not going to pay for your mortgage. He's not going to pay for all those things that you would have been able to earn had you not suffered these injuries. So what do you do next? Well, now you wind up going to an attorney. Okay, I got the first cufflink in. Here we go. The first cufflink is in, and now we're going to try and go after the second cufflink at the same time. So now you try and find the best attorney you can. And now, as you believe you find the best attorney for you, he goes ahead and decides, you know what, you may have a possible case. But in order to know for sure whether or not you have a valid case, he's got to get this cufflink in through the wrist. So yes, this is exactly what he has to do. He has to go ahead and hire and retain a qualified medical expert, typically a board-certified expert, to go ahead and review and evaluate all of your medical records. Only after the expert has reviewed all of your medical records can he now confirm or turn around and say, no, I'm sorry, you don't have a case. But here's what he has to confirm. Okay, now we're making progress on this other cufflink. He's got to confirm, number one, that there was wrongdoing, that your doctor violated the basic standards of medical care. Second, he has to show that that carelessness, that wrongdoing, was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. There could be multiple causes. All right, so now let's start working on the other half of this cuff for my cuff link, because I want to see how this looks. And then, after the second thing, after he's able to show that the carelessness was a cause of your injury, now he has to be able to confirm that your injuries are significant and or permanent. Only then are you permitted to bring a lawsuit against your doctor. So, let's assume, here we go. Success. All right, I've got the cufflinks in. They match exactly what my studs look like. Now that's great. Now I'm going to focus on my bow tie. I'm going to get this up, my collar up. I'm going to close up the top. And let's see how this looks. It's so weird because I don't have the mirror, but instead I'm using the viewfinder on the camera. And hopefully this is going to work while I'm doing this. All right, so remember, once the medical expert has confirmed that you have a valid basis for a case, that is the only time that you are permitted to go forward and bring a lawsuit against your doctor or hospital staff. So you've done that, right? So now the scenario is you've brought a lawsuit, you've got confirmation by a medical expert, and now as I try to get the bow tie tied and clipped, there we go, now we got it. Now I got to pull down the collar. This is not a wingtip shirt. This is a regular button-down collar. Actually, it's not a button-down because there's no button to hold the collar down. All right, so there we go. Now we've got the bow tie, we've got the suspenders on, we've got the studs, we've got the cufflinks. I think we're ready to go. Awesome. So let me continue on as to what happens. So now the doctor gets the lawsuit papers and says, hey, why are you suing me? I don't understand this. I did nothing wrong. That's what he's claiming. And then he turns around and says, you know what? Maybe if I did something wrong, guess what? So did you. You did something wrong to cause or contribute to your own injuries. You didn't listen to what I had to say. That's his second defense. And then he says, you know what? Maybe if I did something wrong, guess what? Whatever I did or didn't do did not cause or contribute to your injuries. And now he says, okay, if I did something wrong and whatever I did caused your injury is really not as bad as you claim it to be. Those are the four typical defenses we see in these medical malpractice cases. And by the way, the doctor's attorney tells your attorney, hey, listen, we're never going to settle this case. We are never going to negotiate. So we'll see you at trial. Now, what does that mean for you? It means that now your case is going to go through the litigation process. And the first part of the litigation process is the discovery phase. Now, what does that mean? It means you get to discover, you by your attorney. Your attorney gets to discover certain things from the defense. The defense gets to discover certain things about you and your case. They get to exchange medical records. Permission slips to get medical records are exchanged. Other records are exchanged. All that happens during the course of the discovery phase. In addition, you will have an opportunity to give testimony, pre-trial testimony, in your lawyer's office. It's really a question and answer session that's given under oath in your attorney's conference room. You are there, your attorney will be there, the defense lawyer will be there representing the doctor or hospital that you sued. And now there's no judge there, there's no jury there, but there is a court reporter there to record all of the questions that you're asked and all of the answers that you are giving. And that gets transcribed and put into a booklet. And that is the basis of your pretrial testimony. And you should know that carries the same exact weight as if you are testifying at the time of trial. So don't think that just because you're answering questions in your attorney's office that it's okay if you forget stuff, it's okay if you tell a little white lie. No, no, no. It is as if you are testifying at the time of trial. Just so happens it's being done in the discovery phase, in the pretrial process, and everything you say is being recorded. So what happens then? Well, a few months later on, we will then have an opportunity to question the doctor whom you have sued. This is called a deposition, this question and answer session. We also call it an examination before trial. So now, after we've had an opportunity to question the doctors and any other witnesses that we believe are necessary, then your case gets put on the trial calendar, letting the court know, hey, judge, this case is ready for trial. Well, it doesn't mean that your case is going to get to trial right away. Why? Because there's a stack of other cases ahead of yours, and now, slowly but surely, your case will rise up to the top, and at some point, maybe 6 months down the road, after your case has been ready for trial, maybe a year, it depends on the backlog in each particular court. So now, your case ultimately will get to trial. What does that mean, that your case gets to trial? It means you're going to have to put on proof. You're going to have to show to a jury, 6 members of the community, that you are more likely right than wrong, that what you are claiming is true. That's how you go ahead and put on proof. That's how you go ahead and show that you are entitled to a verdict in your favor. Now, what does that mean, that you're putting on proof? Well, we have to go ahead and bring in various witnesses. We have to have people testify and answer questions in front of the jury so that they can hear, they can see, they can look at the documents, the evidence that we have in order to support your claim. Remember, I said earlier you have to have a medical expert confirm that you have a valid basis for a case? Well, guess what? At trial, we are obligated to bring in a medical expert to support our claim. Typically, it's going to be the same expert who reviewed all of the records at the very beginning of the case. But in some cases, it's going to be a different expert, and that's okay. In some cases, we're going to have multiple experts in different medical specialties. And maybe we'll have economic experts to talk about the finances. Maybe we'll have rehabilitation experts to talk about those things you are trying to do but are unable to do. Maybe we'll have people in the workplace to go ahead and explain why your physical disabilities prevent you from doing certain types of work. All of these things are extremely relevant to show to the jury and help them understand why you're no longer able to do those things that you used to be able to do. And of course, don't forget, you will be testifying as well, assuming, of course, you can testify. Okay, so now the defense has an opportunity to go ahead and put on whatever testimony and evidence they feel is necessary in order to defend their particular claim. But remember, they're going to bring in medical experts who clearly contradict things that our medical experts said. And by the way, I was only going to try on my tuxedo shirt. During a break, I realized, you know what? Let me go ahead and try on my jacket as well and see how that looks. All right, so while I'm telling you about the defense case, now I'm going to put on my tuxedo jacket, and I also took off the suspenders in the meantime, and let's see how this looks. All right, here we go. Let's put this down. Excellent. There we go. Now I just need a towel on one side and a bottle of champagne on the other, and I can go ahead and serve my guests. How do you like that? All right, here we go. Looks good in the viewfinder. So here's what happens. So now the defense goes ahead and puts on whatever evidence they feel is necessary to defend the case. And then what? Well, then at the end, the attorneys get an opportunity to make closing remarks. We call them closing arguments. And attorneys will use passion. They will use logic. They will use reasoning to try and go ahead and get the jury to understand why each side is entitled to a verdict in their favor. And guess what? The whole goal is to try and get the jury to realize that you are entitled to a verdict in your favor, to show that you are more credible, more believable than the other witnesses. And by the way, the jury doesn't have to sit there for hours and days and weeks and months trying to figure out and make absolutely certain that what you are claiming is true. Because that happens to be a real concern for some of these jurors, especially during jury selection. They turn around and say, you know what, Mr. Oginski, do we have to sit here for days and weeks making absolutely certain that what you're claiming is true? And the reality is no, that's not what happens. And in fact, we tell those jurors that they don't have to sit here for days and weeks trying to make absolutely certain, make absolutely sure that what we are claiming is true. Instead, we only have to show that we are slightly, just slightly, more likely right than wrong in order to justify a verdict in your favor. Not 75% right, not 85%, not 90%, just 50.1, even 50.0001, just tipping it ever so slightly in our favor. That's enough to justify a verdict in our favor. But you should know that the defense attorney goes first when he makes his closing arguments. We are the ones who get the last word in. Actually, that's not totally correct. The judge is the one who gets the last word in. Because after we attorneys go ahead and make our closing arguments, the judge then goes ahead and spends at least an hour talking to the jury and explaining to them what the law is in this particular case. After they have heard the attorneys give closing arguments, after they have heard the judge give explanations about the law, now the judge explains to them that the jury has to go back and begin deciding whether we are entitled to a verdict in our favor. Now, how do they do that? They're not just told, go ahead and decide this case. That's not what happens. That's not how any of it works. Instead, what happens? What happens is that the judge gives the jury a set of questions that they have to answer. We call those things jury interrogatories. And those are specific questions that the jury has to answer in order for them to reach a verdict. And the verdict has many options. So typically in a medical malpractice case, the very first question that the jury will usually answer is, was the defendant negligent? Now what does that mean? Well, the defendant is the person that you have sued. In this case, it's a doctor. So, was Dr. Jones negligent? Well, negligence is nothing more than carelessness. In this case, involving a claim against a doctor, it's medical carelessness, the carelessness of a medical professional. Yes or no? If the jury decides no, that's it, your case is over, you get nothing. That's the end of the case. If the jury, however, says yes, the doctor was careless, he violated the basic standards of medical care, now the jury then goes to the second question. Then they have to answer, was his carelessness a cause of your injury? And the legal phrasing is, was that negligence a proximate cause of your injury? And what that really means is, was the doctor's carelessness a cause of your injury? There has to be that link, that bridge, that connection between the wrongdoing and your injury. If there's no link there, if there's a gap, if there's something, a disconnect, guess what? Then the jury says, no, your case is over. So even if they found that the doctor was careless, but his carelessness did not cause your injury, your case is over. And you go home without anything. All right? So now, let's assume for a moment that the jury has decided that yes, the doctor was careless. And yes, his carelessness was a cause of your injury. Now they have to answer the next series of questions. And those next questions are going to focus on how much money you are to receive as a result of your doctor's carelessness. Now they're going to focus on damages. Because once they have determined that yes, your doctor violated the basic standards of medical care, the jury has already determined that your doctor is legally responsible. And now that his carelessness caused your injury. Now the jury has to get to work to decide how much you are to receive for each element of damages that you are claiming. Are you claiming lost wages? Are you claiming pain and the suffering that you endured from the time of the wrongdoing up until the time of trial? What about into the future? Let's say you're expected to live another 25, 35, 40 years. Well, the jury has to take that into consideration to decide how much you are to receive each and every year cumulatively for the total amount of time you can be expected to live. And they have to evaluate other elements of damages as well. And we're not going to go into detail about those, but just understand, once they get to that point, now it comes time to calculating or determining how much money you are to receive. So let's say, for example, that the jury comes up with a total global amount of $5 million that you are supposed to receive as compensation for all the harms and injuries and losses and damages that you incurred because of your doctor's carelessness. And now they've come to a decision. They've come to a conclusion. They tell the judge they have a verdict. And now everybody in the courtroom is nervous. Everybody is anxious, because anything could happen when the jury goes out to deliberate. But now they come back with a verdict. The judge asks them to read the verdict. And now he looks at the verdict, he hands it back to the jury foreperson, and now, one by one, he asks them to answer the question in open court. Mr. Foreperson, was the defendant, Dr. Jones, negligent? We, the jury, find yes, he was. Okay, it's question number one. Question number two, was the doctor's negligence a proximate cause of this patient's injuries? We, the jury, find yes, he was, or yes, it was. How much money do you give the injured patient for the suffering and the pain that she endured from the time of the wrongdoing up until the time of today, the time of trial? We give her $3 million. And for her pain and for her suffering from today into the foreseeable future, how much do you give her? We give her $1 million, representing the course of the next 25 years. And how much do you give her for her lost wages? We, the jury, give her $1 million for her lost wages. And how much do you give her for her medical expenses? We, the jury, decide to give her $50,000 for her medical expenses. And how much do you give to her spouse for a claim of loss of services based upon her injuries? We, the jury, determine that her spouse is entitled to receive $100,000. So it turns out that if you were to add up all of those things, that comes to more than $5 million. You are thrilled. You want to jump up and down. You want to do the touchdown dance. At least your attorney wants to, but he's not going to. Why not? Because professional attorneys do not do that. They take these verdicts in stride. Your attorney is going to be thrilled. You are going to be thrilled. The defense attorney is not going to be thrilled. The doctor's not going to be thrilled. But the jury is told that before they go out to deliberate, they are not to consider who their verdict is to help and who their verdict is going to harm. That's not for them to consider. The judge also tells them, do not consider sympathy. Not sympathy for the patient, not sympathy for the doctor, not what will happen to his reputation, not what will happen to his license of practice. None of that. You are to decide this case on the facts and the evidence as we have given it to you. That's it. And you are to make your decision based only upon that information. So, you are thrilled, and you believe that the doctor is now going to pull out his checkbook, write a check for more than $5 million, and say, hey, here you go, patient. Have a nice day. No, no, no. That's not how it works. That's not how any of it works. What's going to happen then? I'll tell you what's going to happen then. As soon as the jury has reached their verdict, the defense attorney is going to jump up and ask the jury to be polled. Now, what does that mean? It means he wants to make sure that this verdict really represents what the jury has decided. So the judge or the court officer will ask the juror, hey, juror number one, is this your verdict? Yes, it is. Juror number two, is this your verdict? Yes, it is. And now he'll go through each of the 6 jurors to make sure that this is their verdict for each and every question. Now, again, you should know, you don't have to have a unanimous decision. You don't have to have all 6 people deciding that you are entitled to a decision in your favor for each and every question. Instead, you only have to have 5 out of 6 agree. And for each question, it doesn't have to be the same 5 who agree. It can be different 5 people. So you only need 5 out of 6 people to agree on any particular question. So now the defense attorney has polled the jury. Everybody has agreed that this is their verdict. And now the judge thanks the jury. He says, ladies and gentlemen, thank you for your jury service. You've now done a wonderful thing. You've served your civic duty. We thank you. The court thanks you. The county thanks you. The citizens of the state of New York thank you. And he sends them out with further instructions. Then what happens next? The defense attorney, instead of telling his doctor to go ahead and write you out a check for millions of dollars, immediately jumps up, says, Your Honor, I move to throw out the verdict as being against the weight of the evidence. What's that about? Well, the defense attorney has to make certain requests to the judge at this point. These are formalities. Now, unless something horrendous and something so bizarre has occurred that it immediately needs to be thrown out, in all likelihood, the judge is going to turn around and say, Counselor, I'm going to reserve decision on your request. If you really want me to consider throwing this verdict out, you have to go ahead and obtain the trial transcript, whether it's for 2 weeks worth of trial or more or less. You go ahead and get in touch with the court reporter. You now get the entire transcript that you have to pay for, and then you prepare written papers together with case law to support your request that we throw out this verdict. And now the judge will give the defense lawyer time to do that. Likewise, after that's submitted to each side, he will send a copy to us, he'll send a copy to the court. Now we have to have an opportunity to go ahead and read through it, and then time to respond. So now we have to go through that testimony again. We have to prepare a legal brief to explain to the court why the verdict was totally justified. This could take a month, it could take 2 months, it could take more. And then we might even have oral argument in front of the judge a few months down the road. And then if there is oral argument, the judge will likely turn around and say, you know what, I'm going to reserve decision and make my decision based upon your oral argument as well as what's contained in your papers. So what happens next? The judge then has a number of options. This is the judge who tried this case. He can agree with the defense lawyer and say, you know what, the verdict is not supported by the evidence. We're going to throw this case out, and then you're going to have to try this case all over again. Or he could turn around and say, no, defense lawyer, the verdict is supported. Your request is denied. Or he could turn around and say, you know what? I don't like the verdict. I think it's too high. I think that this verdict should only be $3 million instead of 5 point something. And if everybody agrees, great, case is over. If everybody doesn't agree, guess what? The verdict gets thrown out. You guys go ahead and start this trial all over again. That's a possibility. Or the other possibility is the judge can turn around and say, you know what? I don't like this verdict. I think that you should have gotten more money than what the jury gave you. So if everybody agrees to give you more money, let's say $7 million, case is over. The likelihood of the defense agreeing to that is 0. 0. So what happens then? No matter what decision the trial judge comes out with at this point, the defense is going to go ahead and appeal the judge's decision. They're going to appeal the verdict. Why? Because they lost. They lost big. And there's no way they're going to roll over and take that as a final answer. You know, on the show Who Wants to Be a Millionaire that Howie Mandel ran, the question was always, is that your final answer? Well, the defense will never accept it as a final answer, and they will continue pushing and pushing and pushing until they've reached a dead end, and they get a final answer from a court of a higher jurisdiction. So where do they appeal? They appeal to the appellate division of the state of New York. And each county is assigned to a particular division, the appellate division. There's the first department, which is Manhattan and the Bronx. There's a second division, which is Nassau, Suffolk County, and Queens. And there are other divisions as well. So depending upon where your case is tried, that will determine which appellate division your case is going to be heard. Now you should know something, and this is really important. When your case gets appealed, it could take 1 to 2 years from the time of the appeal until that appeal is resolved. Because remember this, whoever appeals that case does not automatically get a new trial. There is no new evidence going to be presented. The appellate court looks to see, number one, if there were legal errors made. And if there were, they look to see, did that make a difference? Is there a good likelihood that the outcome would have been different if this legal error had not been made. Let's say a certain document or a certain medical record had not been admitted into evidence. Would that have changed the outcome of this case? If a certain piece of testimony had not been elicited during cross-examination, would that have changed the outcome of the case? If they find that a certain witness should never have been allowed to testify, is that what caused this outcome? And if the appellate court decides, yes, this was a legal error that was made, and yes, it did alter the outcome, now the higher court has a number of options. They can throw the entire case out. They can reduce the amount of money that you've been given by this jury. They could, on the other hand, increase the amount that you've been given. They could turn around and say, you know what, we don't like the verdict at all. We're going to tell you to go back, try this case all over again, or maybe just try it on damages to assess how much money you are to receive for the various elements of damages you're claiming. They have many options available. So the title of this video was, if you get a significant verdict in the millions of dollars, does that automatically mean that the doctor's going to get out his checkbook and start writing? The answer is no. The defense is not going to accept that as the final decision. Instead, they're going to ask the judge to throw your case out. They'll ask him to reduce the verdict. And if that doesn't work, and even if it does, they'll still go ahead and appeal further. And then they'll ask the appellate court to do those same things. And only after they get a final decision from the appellate court, at that point they'll have to decide what they want to do. So there's one more thing I should tell you about. Besides the fact that I look pretty decent wearing my tuxedo, I got my bow tie on, my tuxedo shirt, I got my cufflinks in, and now I'm all set for my daughter's wedding. Too bad it's not today, because then I could just get up and go. But the other thing that you need to know about is that even once you reach a final decision from the appellate court, it is still possible for you to settle your case. Could you believe that? Could you imagine that? After all these years of litigation, where the defense refuses to acknowledge they did anything wrong, the defense refuses to negotiate, now you go through trial, you get this great verdict, now you go ahead on appeal, and now as a final decision, the appellate court says, yes, you've got to pay, meaning the defense, the doctor has to pay. They can still go ahead and try and negotiate and try and settle your case. But that's a topic for another day. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on with these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions, and my dog came in to hang out here. Hi, Bentley. You want to try on a tuxedo too? My little puppy wants to go ahead and participate in the wedding, so maybe we're going to get him a tuxedo or at least a bow tie. But really, if you have questions about your matter that happened here in New York and you've not yet started a lawsuit yet, and now you need questions answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video, everybody. I'm Gerry Oginski. Have a wonderful day, and I'm going to go take off my tuxedo now. Take care, everybody.